We've got some major breaking news in the Quadajah Johnson case because the Illinois Supreme Court has just dealt a significant blow to state prosecutors. The court has officially denied the state's petition for leave to appeal. This means the state will not get another opportunity to argue that Quadajah Johnson should remain detained while awaiting trial. So is Quadajah about to get out of jail? Well, let's break it down. When people do the most, I do the analysis. Let's go. On June 11, 2026, the Illinois Supreme Court issued a one-page order in response to the state prosecutor's appeal effort. The order simply states, "The Supreme Court today denied the petition for leave to appeal." That's it. Simple, direct, no lengthy opinion, no oral arguments. In layman's terms, the court declined to take the case. For those who may be new to the channel, Quadajah Johnson is charged with first-degree murder in the shooting death of Romika Blackman. Back in April, the First District Appellate Court reversed the trial court's detention order and ruled that the state had not met its burden under the Illinois Pretrial Fairness Act. The appellate majority concluded that prosecutors failed to prove by clear and convincing evidence that Quadajah Johnson posed the type of ongoing threat that's necessary to justify pretrial detention. The state strongly disagreed and filed a petition for leave to appeal, or a PLA, with the Illinois Supreme Court. The state's goal was simple: get the Illinois Supreme Court to review and overturn the appellate court's decision. Well, on June 11th, the state's effort failed. A lot of people hear PLA denied and think that it's just procedural, but no, it's actually a very important development. When the Illinois Supreme Court denies a PLA, it means the court is choosing not to review the lower court's ruling. And as a result, the appellate court decision remains intact. The state wanted a second chance, but the Supreme Court said no. That means that the appellate ruling continues to stand. So does this mean that Quadajah Johnson is getting released? Well, yes, but not today. The Supreme Court didn't order Quadajah's immediate release. What happened is that the Supreme Court declined to review the appellate court decision. They essentially said, we're not getting involved. And whatever the appellate court ruled is the ruling that must stand. The mandate is scheduled to issue next month on July 16th. After that process is completed, the case is going to return to the lower court for further proceedings that are consistent with that appellate ruling. There may still be hearings and conditions that need to be addressed. So while this is a major victory for the defense, and we just got to be clear about that, it's still not the same thing as someone walking out of custody immediately. And it's not setting Quadajah Johnson free. It's allowing her to be temporarily released from custody while she fights for her actual freedom outside of the Cook County Jail. So who won today? The defense. And that's without question. The state spent weeks attempting to convince the Illinois Supreme Court that the appellate court got it wrong. The Supreme Court declined to intervene, though, and that's actually a significant win for Quadajah Johnson and her legal team. Now, all eyes turn back to the circuit court, Judge Clancy's court, that is. We're also still waiting on outstanding evidence in the murder case itself, including forensic testing that has delayed the progression of the underlying prosecution. The next scheduled status hearing remains on July 23rd. So while today's ruling is a huge development regarding detention and release issues, the murder case itself is far from over. Based on the Illinois Supreme Court's order, I believe the chances of Quadajah eventually being released pending trial has increased substantially. The state has lost at the appellate level and has failed to obtain a review from the Illinois Supreme Court. That doesn't mean Quadajah Johnson is guaranteed to go home, but Judge Clancy's court has to come up with some kind of pretrial release conditions for her. And it does mean that the legal roadblock prosecutors were relying on, well, it has effectively come to an end. But does this court order mean that Quadajah's going home? Before I answer that question, let me remind y'all of the appellate court's ruling for Judge Clancy's circuit court. In Illinois, there are several pretrial outcomes that do not involve the defendant being released back home, just to live freely while awaiting trial. Yes, Illinois law absolutely allows outcomes where a defendant is not simply released back home. Under the current Illinois system, and this is after the Pretrial Fairness Act changes, judges generally have three broad options after a detention hearing. Number one, they get pretrial detention. That's jail time and no release. That's when the court finds the person poses a real and present threat to a specific person or to the community, or a serious flight risk that cannot be managed with conditions. And then there's custodial / residential placement, and that's not home release. In some cases, instead of jail or home release, courts may use structured placements such as an inpatient mental health treatment facility, a substance abuse treatment program, or residential supervision programs. In these settings, the person is still in custody or court supervised housing. They are not free in the community and their movement is controlled and monitored. Now, this is less common, but it is an option when treatment needs are essential to the case. And then there's non-home conditional release, and that's strict supervision outside of the home. Even when someone is not detained, Illinois courts can impose conditions that are more restrictive than simple go home and wait for trial, such as electronic monitoring, that's the ankle monitor with the GPS tracking, or 24/7 curfews, sometimes requiring someone to be at a specific approved location. There's mandated placement in a shelter or a structured housing program. There's also intensive pretrial supervision. I'm talking about mandatory check-ins and drug testing and even travel bans. And there's no contact or exclusion zones, and that meaning that they can't enter certain areas or approach certain people. There is an important nuance that I need to mention here, though. Most release options still involve the person living somewhere, and to be perfectly honest, is usually home. But courts can restrict where, how, and when they move. They can do it so tightly that it functions like controlled confinement outside of jail. But here's the bottom line, y'all. The state took this fight all the way to the Illinois Supreme Court and lost. The appellate court ruled against them. The Supreme Court declined to step in. And now, one of the biggest legal obstacles standing in Quadajah Johnson's way has been removed. Of course, the murder case itself is far from over, and no one should confuse the Illinois Supreme Court's ruling with a verdict of guilt or innocence. But when it comes to the battle over pretrial detention, the defense just scored a major victory. Now the question remains, will Quadajah Johnson finally be released home pending trial? Or will prosecutors find another way to keep her detained? We're about to find out. If you enjoyed this video, please give it a thumbs up and share it with someone who can use this message. Subscribe to the channel if you haven't already done so, and leave a comment down below letting me know your thoughts. Do you think Quadajah Johnson will be going home on pretrial release? Meet me in the comments. we can continue the conversation there.